Try that again. Wow. All right. Hold on. Sorry. That's my bad. Wow. All right. Sorry about that. Yeah. I forgot to turn on the mic. Always a problem. Let's try that again from square one. Hello, everyone, and welcome to Uncivil Law. I hope you are having a wonderful day. And we are here with a brand new lawsuit that was filed by our friends at Uber. This is on the basis of what is known as Assembly Bill 5. We have done a story on this already when it became a law. We reviewed the law, we covered it, we read it, and we talked about how some of its implications were going to be. We noticed that it's going to have severe implications for the gig economy, both for Uber and delivery services like that, and perhaps even more notably, arguably, for journalism, because there are a lot of small media companies, and large ones for that matter, who use contractors to write the majority of their stories. So this is going to impact people like BuzzFeed and Vox and all the rest of it, because they would have to have them as employees. So basically what the law says, in so many words, is that if you have someone who works for you in the course of your regular scope of business more than so many hours, I think it is per month. I think it might be like 1 hour per month, or I forget exactly what the number is, but it's a pretty small number. Then you have to treat them as employees, not as contractors. And that difference comes with a whole host of interesting implications for a company. If a person is an employee, you have to pay for unemployment insurance. So you pay so that if they're fired, they can get unemployment. If they're a contractor, you don't pay for unemployment insurance, and they can't get unemployment because they're their own company. You have to pay for health care benefits, which you don't have to do if they're a contractor. You have to, have certain workplace safety rules that don't apply to contractors, because the idea is that they're working at their own workplace, they're working on their own time, they're working at their own facilities, using their own equipment. So a lot of the workplace rules that normally apply don't apply to contractors. So it can become a money-saving exercise for companies. And Uber, of course, is taking advantage of this. And they wanted an exemption to the law. There were exemptions given to the law, and Uber did not get one. And Uber, as I understand it, is complaining that this not giving them an exemption, but giving other people an exemption is due process violation. That because the state of California has no rhyme or reason to its exemptions, that it's a due process violation, and therefore it's unconstitutional. If that's their argument, I'm telling you right now, it's not going to work. So my presumption going into this lawsuit is not going to work. But we're going to read it and see if there's anything in here that changes my mind. And as Higgins points out, liability for workers, also workplace insurance for injuries, things like that would also apply for accidents at the workplace. That's also a huge factor. So we're going to read this. Now, in case you're wondering what makes an employer versus a contractor as a matter of federal law, there's like a 13-factor test. We discussed that on stream when we discussed the Assembly Bill in the first place. But among other things, whose equipment is being used, who sets the hours, where is the workplace, does it require independent skill, or how much managerial control is there, how much direction is there, multiple factor tests like that normally makes this distinction between employer and contractor. And Uber's argument was, well, Uber employees use their own cars, so they use their own equipment. They set their own hours. They decide when to work. The place of work is their car. It's not our facility. There's very little direction or control in terms of, what they have to do. They can generally drive in the areas they want to, and we tell them, if there's rides, but they can always decline a particular ride. And so the idea was that they're a contractor, not an employee. And California wants to change that as a matter of state law, which they can do. So we're going to review this lawsuit and decide whether or not this is unfair. So let's get started with the lawsuit. And we are going to read this more or less in full. So you guys are going to have the pleasure of my voice for a little bit of time because we're going to be reading this in detail. So let's get started with this and see what they have to teach us from the people at Uber. And standard disclaimer, of course, applies. Because this is a complaint written by Uber, you should expect everything to be written in favor of Uber and anything that is downside minimized. So, remember the source is always a good thing. This is by Uber. So it should be written, it is written with Uber in mind, in favoring them. So nothing is going to be false, hopefully, but everything will be colored to the maximum extent possible to give them the best possible case. So we should read it with the bias in mind that definitely applies. Okay. Plaintiffs Lydia Olson and Miguel Perez and Postmates and Uber Technologies file this complaint for declaratory, injunctive, and other relief. Declaratory relief is, please tell us what the state of the law, please tell us what the law is, or please tell us what our obligations are. Declare what is true. Injunctive is, please force someone to either do something or stop from doing something. Either one is injunctive. And other relief, determining that California Assembly Bill 5, AB5, a recently enacted statute that becomes effective on January the 1st, 2020, is unconstitutional. They really waited to the last minute on this one, didn't they? They really waited to the last minute to file this thing. So, yeah. AB5 violates the equal protection and due process clauses of the 14th Amendment to the United States Constitution. Probably not. The 9th Amendment to the United States Constitution. How? And the Contracts Clause of Article 1 of the United States Constitution. I kind of wish it did, but that clause has been severely constrained, but why not throw that in there? As well as the Equal Protection Clause. No. Inalienable Rights Clause. No. Due Process Clause. No. Baby 9th Amendment. I don't know, and Contracts Clause of the California Constitution. So we're going to read a lot about California-specific law and see if they can make their case under California-specific law. I think their federal case does not exist. Plaintiffs bring this lawsuit to protect their constitutional rights and defend their fundamental liberty to pursue their chosen work as independent service providers at technology companies in the on-demand economy. AB5 is a rational and unconstitutional statute designed to target and stifle workers and companies in the on-demand economy. If it were truly irrational, they would win because, at the bare minimum of legal, you need rational basis for the government to do. So if it's truly irrational, then it couldn't be rational basis, and therefore it would be unconstitutional. The rational basis is pretty thin. The on-demand economy is a free market system in which plaintiffs Lydia Olson and Miguel Perez, along with other independent service providers like them, have enjoyed opportunities to earn money when and where they want, with unprecedented independence and flexibility. These opportunities have been made possible by mobile applications, apps, operated by network companies that connect consumers requesting certain services with independent providers of those services. Network companies that operate these apps, like Company Plaintiffs, are sometimes referred to as app-based platforms, network companies, or platform companies. Those independent service providers who find their customers use the network company's mobile apps may be referred to as app-based independent service providers performing on-demand work. Plaintiffs Olson and Perez choose to work as independent service providers in the modern app-based on-demand economy as a means of earning substantial or supplementary income while maintaining the right to decide when, where, and how they work. In fact, hundreds of thousands of Californians choose to provide these services, such as providing transportation to passengers or delivering food, groceries, or other goods, and enjoyed unprecedented level of flexibility and freedom without restrictions, limitations, and burdens of traditional employment. Yeah, that part is more or less true. Because being an employee comes with burdens to the employer, as we've discussed, but it also comes with burdens to the employee. As an employee, they have the ability to determine where and when you work. the constraints of which they determine your pay and determine they could set a base salary for you. They could put you on salary. They could set an hourly wage, and then everything else Uber keeps. So it comes with negative benefits too. They can say we're going to pay everyone $50,000 a year, and you have to work for us 8 hours a day, and if you don't, we'll fire you. So it comes with negative repercussions to the contractor as well. Such independent services providers like independent plaintiffs are able to integrate work into their existing lifestyles, to manage it along with other work, and to assemble what amounts to form of income insurance, thereby gaining the ability to provide their own financial stability. For example, Plaintiff Olson uses his on-demand work to supplement, her primary income while still ensuring that she can always care for her husband, who has multiple sclerosis, whenever he needs her. Plaintiff Perez uses on-demand work more regularly to earn a more substantial income than he did previously as a trucker, while still making it to all his son's Little League games. How touching. Other fathers, too, choose app-based on-demand referrals for flexibility to work around their children's soccer games or ballet performances. I bet they do. An aspiring comedian might choose to perform transportation services referred to throughout the app so that she can attend an audition without having to check with her boss. A student might choose to use the delivery platform referrals to earn money between classes. A retiree might use the app's referral to supplement fixed income and for social interaction. A military spouse might choose to work on the on-demand economy to help ease the burden of frequent relocation. Others might choose it as a way to supplement traditional full-time work or to bridge the gap between salaried positions. In short, these independent workers can work as much or as little as they want to accommodate family, social, professional, academic, and other commitments. So, Uber, being a smart company, and their lawyers, being smart lawyers, are trying to make this sound as good as possible for the employees, right? They don't want to make it sound like mean, greedy Uber. They want to make it sound like we're doing this for the benefit of the employees. Whether or not you believe that or not, of course, is up to you. But, is a reasonable line of argument, right? Because app-based work empowers individuals to generate income on a flexible schedule, many people choose this mode of work even when they have other options. Even with record low levels of unemployment, hundreds of thousands of Californians are flocking to on-demand work. Instead of a daily commute, an outdated workplace hierarchy, and the daily grind of an inflexible 9-to-5 job, these workers enjoy the freedom to be their own bosses, set their own hours, and earn income whenever they want. Man, they're really laying on the libertarian workers be free shtick pretty thick, aren't they? Man. Many such workers also choose to multi-app, simultaneously use the apps of several app-based network companies. By using multiple apps at the same time, Uber, Postmates, Grubhub, and DoorDash, which I assume are all owned by Uber, which is why they didn't mention Lyft. Independent service providers can more easily find service requests to perform, including multiple service requests at the same time, thereby maximizing their potential for earnings during the time period they choose to make themselves available. Plaintiff Olson and Perez both regularly multi-app to increase convenience and enhance their earnings. Plaintiff Olson holds an MBA from the University of California, Davis, and was employed in several managerial positions before becoming an independent business owner in 2011. She runs a consulting firm that works with small businesses and churches. Shortly after she started her consulting business, her husband was diagnosed with multiple sclerosis, and she was grateful that, as an independent business owner, she had flexibility to take time off to care for him when needed. In addition to her consulting work, Ms. also began using the Uber and Lyft apps for driving referrals to supplement her primary income while still maintaining the flexibility to support her husband. Given her husband's illness and the fact she has little to no notice on when she will have to take time off for him, as well as her consulting business, Ms. Olson could not give up the flexibility she has as an independent service provider in exchange for a more traditional work employment arrangement. Plaintiff Perez likewise has relied on the freedom and flexibility he has as an independent contractor to support his family. He once drove a big rig as a commercial Class A truck driver for FedEx on a regular graveyard shift. He disliked the inflexible schedule and long hours because of how little time he got to spend with his wife and children, and found he was constantly getting injured on the graveyard shift. Mr. Perez's dissatisfaction led him to look for other work and decide to experiment with running his own on-demand business on his own terms by accepting referrals to customers looking for rides or deliveries from several on-demand apps. Now running his own delivery business, Mr. Perez decides when to start work and when to stop. He's even able to be his own boss and tailor his work to present for all the more important life events of his children, and nearly doubled his earnings, from which he was a truck driver, allowing his wife to quit her job and spend more time with their daughter. Individual plaintiffs experience these benefits from on-demand work as tangible and central in their families' well-being and quality of life. These benefits represent foundational and critical gains they realize every day from being their own bosses. The app-based on-demand economy has also benefited consumers. The advanced technology of the app network companies like Company Plaintiffs have reduced the costs associated with finding and hiring independent service providers, eliminated barriers to enter high markets with high initial setup costs, increased convenience for independent service providers and consumers, and lower prices for numerous services by making it easy to connect independent service providers directly with paying consumers. As a result, consumers have flocked to network services because of the added convenience, low price, and high quality of services. Millions of California consumers and brick and mortar businesses and the state's economy as a whole have benefited from services of these independent service providers and the on-demand economy. Some of the many benefits to consumers, small businesses, and the public from on-demand economy include providing convenient and affordable transportation, reduced impaired and drunk driving, improved mobility and access to local merchants for seniors and individuals with disabilities, providing new transportation options for families who cannot afford a vehicle, fostering growth of small businesses that were able to reach a broader market, and providing new, affordable, and convenient consumer outreach options for local businesses and their patrons. These benefit workers, consumers, and merchants, and the public as a whole, have been fueled by technology companies like Company Plaintiffs, creating and operating websites, apps, and other technologies that instantly connect independent service providers willing to perform a service for companies willing to pay for the service. For example, among other plaintiffs, Plaintiff Uber operates an app-based platform that connects consumers looking for rides with drivers looking to provide such rides. Plaintiff Postmates operates an app-based platform that connects consumers wishing to purchase goods, such as food, with merchants and independent couriers willing to deliver the purchased goods. Other network companies operate online platforms that match independent service providers with persons willing to pay for someone to any multitude of other services. Evil Coleslaw asked, what kind of truck was he driving and how little was he driving it? Well, we saw he was driving a Class A truck for FedEx on the graveyard ship, according to the complaint. As we read earlier, how much he was driving it, I don't know, but he was an employee, so one can assume that he was in regular employment. So 40 hours a week or thereabouts, one would imagine, without more, right? So apparently that's what he was doing. Importantly, the only service that network companies provide is access to an app. So that's real nice. They're making sure that they're like, we're not a taxi company, right? Nice touch. That's really not the issue, by the way, whether or not they're a taxi company. It's irrelevant to this issue. But, might as well throw that in there too. Neither company plaintiff hires drivers or delivery person. They are technology companies that create and operate apps which facilitate the connection of consumers and independent service providers, so consumers can hire independent service provider to perform particular services. Yeah. Again, whether or not you believe that is a whole nother thing, but of course, Uber wants it to be true, so why not? This is written from the perspective of Uber, so of course that's what it says. Network companies have been an engine of economic growth, innovation, and work opportunities in California, across the country, and around the world. Very moving. Rather than embrace how the on-demand economy has empowered workers, benefited consumers, and fueled economic growth, some California legislatures have irrationally attacked it. California Assemblywoman Lorena Gonzalez, in particular, published an op-ed in the Washington Post in September 2019 unfairly attacking on-demand work, Uber, and other network companies. Well, she is entitled to her opinion like everyone else, so okay. This hostility towards the on-demand economy has led Assemblywoman Gonzalez and many of her colleagues in the California legislature ultimately that led to the passage of AB5. Assemblywoman Gonzalez was the lead drafter, sponsor, and proponent. The California legislature passed it. It was signed and scheduled to take effect. Okay. Assemblywoman Gonzalez and other legislators who have voted for AB5 have publicly and repeatedly stated their purpose in supporting the statute is to force network companies to change the classification of workers who use their technology from independent contractors to employees and thus restructure their business. Yes, that is exactly what the bill does. We don't need to read between the lines or look for real purpose. You can just look to the text. It's pretty clear that's what they're trying to do. In other words, their goal is to deprive workers of flexibility and freedom of their current independent status and instead place them under authority, control, and direction of the employer. Well, that's part of it. But that, of course, comes with, with the bitter comes the sweet, with the good comes the bad. It comes with unemployment insurance. It comes with health care. It comes with other things. So, that's part of the deal too. The overtly hostile to on-demand work has manifested in Assemblywoman Gonzalez's request that executive officials unfairly and with overt bias use the law to target network companies for immediate enforcement actions. Well, that part may be illegal to the extent that there is targeting of already existing laws. That may be a constitutional violation. It goes to selective enforcement, selective prosecution. Both are more difficult cases to be made, but that's at least more plausible. She explicitly added authorization for the city attorneys of California's largest cities to bring law enforcement actions under AB5 against company plaintiffs. Well, that's a new law. So yeah, the new law gives them new authority. So that's fine, no problem there. And she repeatedly encouraged immediate enforcement actions against network companies. Well, if by immediate you mean once the law goes into effect, then sure. Once the law goes into effect, you have jurisdiction and you can bring immediate enforcement action. You could file on January 2nd for immediate enforcement actions if you wanted. So sure, why not? That's how laws work. At least one such city attorney also publicly stated support for the expansion of enforcement authority under AB5 and expressed his intent to use this authority to do the job directed by the Assemblywoman. Okay, well, city attorney works for city, news at 11, right? Other state and city officials have similarly stated their intent to bring enforcement actions against network companies, including company plaintiffs. A. Headingter says that section has so little meaning about to challenge it. Yeah, there's no reason to challenge it. This is all prelude. This isn't law. This is coloring the story. So, I wouldn't expect them to challenge it directly. I'd just expect them to lay out their own version of this, probably without there's no reason to answer it, right? It's not law. It's just here's our story. This is good storytelling though. Storytelling's important. So, they want to tell a story, that's fine. And they're doing a fairly good job of it. Assembly Bill 5 is vague and incoherent statute. I didn't find it particularly vague and incoherent, no. It does not accomplish what sponsors have said they sought to achieve. That's quite possible that it won't set to do what it seeks to do, but that is not a basis to invalidate a law. If we invalidate laws because they don't do what they seek to do, we'd have a lot fewer laws, which may be good, but it's not the way that reality works. Company plaintiffs maintain that, among other things, they are not hiring entities under AB5 and can establish app-based independent services or non-employers under the ABC test. So they're saying the statute doesn't apply to them. Okay, fine. If the statute doesn't apply to you, then you're all set. So why are we here, right? If you really believe the statute doesn't apply to you, then that's fine. But that's why they want declaratory relief, to make sure they're not breaking the law, right? So that makes sense. But if the enforcers of AB5, nice word, enforcers, such as defendants, executive officials, or the 4 city attorneys whom AB5 purports to deputize into enforcer of state law, which, again, is not like unusual. The state can like designate anyone it wants to enforce its laws, right? The city attorneys they're attorneys of the cities, but the cities are creatures of the state. So if the state government wants to give authority to city officials to enforce its law, fine, you can do that. This would deprive independent service providers, such as individual plaintiffs, of the flexibility they so value in working on the on-demand economy. And it would impose economic, administrative, and other costs on platforms such as company plaintiffs by requiring them to fundamentally restructure their business models. This all sounds suspiciously like policy arguments. And for policy arguments, you go to the policy-making branches, which would principally be the legislature. You go to the legislature and say, hey, this law that you pass or contemplating passing has all these negative consequences. And you would go to committee hearings and offer testimony. You'd write position papers, you'd lobby, and all that stuff so that they are more informed. And the legislature then chooses to ignore you or not. And I presume all those things actually happened and they chose to ignore you. So you laid out the case, other people laid out the contrary case, they made a policy-based decision. It's the law now. You don't go to courts to do policy. Courts don't do policy. Courts do law. So it's like, whatever. If found to have violated AB5, company plaintiffs could be subject to civil penalties and even criminal punishment. Yes, that sometimes happens with laws. Sometimes when you break laws, you're subject to punishment. Deep thoughts. For some companies, the burden of restructuring their business and potential penalties could force them to stop doing business in California. Again, I presume these are arguments you could have and in fact did make when the law was being proposed, that it would have all these negative repercussions. Either they didn't believe you or they thought it was acceptable or whatever. But you made this argument and either they said, nah, that won't happen, or we don't care, or whatever. That's, decisions that California can make. Maybe it'll turn out to be a disaster of a law and they'll wind up changing their mind back. Once they implement, they'll find out, oh shit, it didn't work and we need to do something else. That could always happen too. Higgins says, sounds like a veiled threat, but they won't act on it. Well, it has happened in other places. It's not really a threat so much as pointing out consequences. Was it Seattle or something I think it was Seattle, Washington, that wanted to put a tax on companies for every worker. So they were going to tax them per worker, and it shut down a lot of businesses. And Boeing, I think, shut down a plant or something and stuff. And one of the city basically said, oh, this is extortion. You're extorting the city. And they're like, no, we're not. It's just that you've changed the economics and it's no longer economical for us to do this. So we're going to shut down this plant and open a different plant because it's no longer economical. We're just responding to the economic realities that you've put in place. So it's just well, here's a bunch of consequences that might flow from this. If it's those, we have the right to have business or not. We have the right to have employees or not. So it's if you put different economic pressures on us, that's going to change the economy and it's going to change our mode and change our balance. So, Higgins said, wow, per worker, that's foreseeably stupid. Yeah, it was foreseeably stupid. And as a result of that, a lot of companies would not open their place inside the city limits of Seattle, including Boeing, which I think had a plant halfway opened. They were halfway in construction at the time. And they just stopped construction on the plant completely because of that law. And then it got repealed as a result. So, yeah. If AB5 were forced against company plaintiffs in a manner consistent with the sponsor's stated intention to require the reclassification of workers in the on-demand economy, it would harm many independent service providers who prefer to provide services on their own schedules via the app-based platforms that network companies operate. Inevitably, forced reclassification would eliminate that flexibility and entrepreneurship that's the foundation of platform-based work. Not necessarily, the terms of employment could allow such flexibility, but of course it also comes with downsides to the company. So because of the downsides for the company, they might well impose more control, because it's like, well, we might as well be getting something out of, this for us. So it's like, you could like have an employee, it's like, work whenever you want, work wherever you want, but it's like, you probably wouldn't do that. And in turn, would reduce the number of people who are able to earn money via on-demand work. A lucky few will secure full-time jobs, but the rest will be forced right out of stable income stream. For example, according to one study, requiring a ride-sharing company, Lyft, to reclassify its drivers and employees and adopt a more formal work schedule for those new employees would lead to 300,000 fewer drivers in California. The displacement of hundreds of thousands of workers who rely on the current arrangement and for whom this performance of work is possible only if they maintain agency over the conditions in which they choose to bring this work will cause them irreparable harm. One wonders why Lyft is not also part of this lawsuit, and one wonders why we only have 2 individual plaintiffs. I mean, it's not like we need a magic number of them, but one would presume we would have more. Assembly Bill 5 has already forced one company to terminate entirely its relationship with hundreds of independent service providers, with only a lucky few receiving positions as employees. Other companies are replacing independent service providers in California with workers from out of state as a result of Assembly Bill 5. And at least 2 lawsuits have already been filed seeking to enjoin and invalidate Assembly Bill 5 as unconstitutional or preempted by federal law. In a thinly veiled attempt to conceal their irrational intent to target and harm network companies, legislatures framed the statute as merely codifying the 3-pronged worker classification test from Dynamex. But the statute does more than that. Yes, it does, by its own terms. It said explicitly we want to codify and we want to extend it. So, yeah. Dynamex adopted an ABC test to determine whether a worker is an employee, not an independent contractor, for the purposes of wage orders, which are quasi-legislative regulations that impose obligations relating to minimum wages, maximum hours, and a limited number of very basic working conditions, such as minimum required meal and rest breaks. Hold on, let me see if I can get the filtering. Hold on 1 second. Let's see if that helps at all with the noise issue. Let me know if that helps at all. Assembly Bill 5 goes much further and codifies the ABC test for not only wage orders, but also for the California Unemployment Insurance Code and the entirety of the California Labor Code. It also attaches the threat of criminal sanctions by making misclassification of a misdemeanor or even felony under California labor law pursuant to penalties provided for in the existing labor code. The irrationality of Assembly Bill 5 is confirmed in its laundry list of exemptions. Assembly Bill 5 spends only a few lines of text adopting the ABC text. I heard it a few times, it's intermediate, not super loud, so I don't know if it was worse on headphones. You know what it is? It's probably the fan of my computer. Will you guys wait for me for 1 second while I duck under the desk and move the computer so the fan is less close to the mic? Hold on. Okay. The computer fan is now further away from the microphone. Just remember, I love you all very, very much. The irrationality of Assembly Bill 5 is confirmed by its laundry list of exemptions. AB5 spends only a few lines of text adopting the ABC test. Yeah, it's already established at law. You don't need a lot of text to establish it, something that already exists. So you don't need to spend a huge amount of text saying what it is because it already exists. The vast majority of the statute is listed of exemptions that carve out the statutory scope of dozens of occupations, including direct salespeople, travel agents, grant writers, construction drivers, commercial fishermen, and many more. There's no rhyme or reason to these nonsensical exemptions, and some are so ill-defined or entirely undefined that it's impossible to discern what they include or exclude. Thank you, Jan. Says, after fan fishing, we also love you. Thank you, Jan. It makes it helpful for me. For example, some types of workers are excluded. Delivery truck driver delivering milk, while others performing substantially identical work are not excluded. Delivery driver delivering juice. The statute exempts professional service providers such as fine artist services, but does not define a fine artist service, leaving individuals guessing whether or not they qualify for the exemption at great financial risk. Well, that doesn't apply to you, Uber. You're not a fine art service. We have a pretty good idea what fine art service means, right? So there's probably some borderline cases where this might be an issue, but if someone has an issue because they're borderline, they can bring a complaint. Nor is there any rational reason why individuals who choose to earn income by direct selling Tupperware is exempt, and yet if the same person earns extra income by offering driving services, there's no exemption. Okay, all right. Brief review of rational basis review. All right. Brief review of rational basis review. Okay, rational basis review is your standard for your baseline standard for legislation, unless there is a constitutional issue or something where a higher standard would apply. In order for a statute or regulation or ordinance to pass rational basis review, it has to be any relation to any legitimate motive of the government. And it doesn't have to be the motive stated in the law. So even if the law states a motive, it doesn't have to be that motive. It can be any motive. So, if you're in court and it's trying to show why the law is legal under rational basis review, all you have to do is show that it has any relation to any legitimate motive. So it's pretty hard to fail rational basis review. Okay. It has happened where things have failed rational basis review, but no, there's a lot of reasons for these people to be exempt. They could have exempted other things they didn't. There's reason to it. I can think of reasons off the top of my head. I don't have to think very hard. Good for you, Jan, I suppose. If you prefer your story time, that'll be good. Maybe Uncle Blackleaf should write a story for you. The targeting of app-based workers and platforms and treating them disparately from traditional workers violates the Equal Protection Clause. Well, no, it doesn't, because they're not a protected class. There's simply no rational basis for subjecting exempt occupations and non-exempt occupations to different rules and burdens. Yes, there is. Whereas here, the breadth of a statute is so disjoined from the reasons offered for the statute seems inexplicable by anything but animus. Nice touch, but no. Towards the class it was designed to affect, the statute lacks a rational relationship to legitimate state interests and violates equal protection. Yeah, it's any rational relationship to any legitimate state interest. Okay? Yeah. And whereas here there does not appear any reason why the California legislature would choose those carve-outs other than respond to the demands of political constituents, which again falls into the category of a rational reason because it's a political process. The law is unconstitutional even over the most minimum rational basis standard of judicial review. Not even remotely close. Not even remotely close. Here's my reaction as Judge Mueller. Ha 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 ha. And to the extent AB5 is enforced against on-demand workers and companies in a manner consistent with the sponsor's stated intent to require a reclassification of workers in the on-demand economy, AB5 violates the inalienable rights and due process clause of the California Constitution, as well as the 14th Amendment to the United States Constitution. Please stop. Please stop. It's so funny. App-based independent service providers and the companies that operate the platforms they use have a constitutional right to pursue the occupation of their choice, not be forced to be employees when they're independent, or forced to be taxi or delivery companies when they're technology companies. And platform companies have a constitutionally protected interest in running their business free from unreasonable government interference, including statutes that irrationally classify and target them as a politically disfavored group. Okay, again, guys, it's not like super complicated. You're allowed, as a government, to have politically disfavored groups, as long as those groups are not protected classes. If they are protected classes, then you have massive constitutional problems, But if not, then it's like, not a problem. So it's like, is Uber a protected class? No. Are contractors as such a protected class? No. Are employees a protected class? No. So yeah, they're politically disfavored. And my response is like, yeah, so what? My response is the legislature is that, yeah, you're disfavored. And therefore, question mark, we can regulate you any way we want. We can prevent your business from existing. We can just shut you down. We can make your business illegal. How's that? We could do that. That'd be fun. It's like, we can do anything we want. This is a political process with political consequences. If voters don't like us, they can vote it out. So otherwise, we can do whatever the hell we want. How'd you like to not have a business, Uber? How'd you like to just shut down your entire business enterprise? We can do that. That'd be fun. I mean, they'd have to eliminate the entire class. They couldn't just like target Uber specifically. They couldn't do that. But if they said like no app-based companies, I mean, obviously that would affect a lot of companies in California, but hypothetically they could do it. Right? So it's like, not a problem. You can do that because these are not protected classes. So as long as you're like doing it to an entire class and not like individual elements within the class. So it's like, as long as you're like doing it to Uber and all similarly situated businesses, you don't have an equal protection problem. It's like, whatever. Yeah. Yeah, A. Headington said if Uber showed a majority of their drivers were minorities, maybe. Yeah, if it maybe, because then you go into like the true motives were really for race-based reasons, so you could go into that issue, but I don't think that argument's going to work. I mean, even if it's true, it's happenstance, and I don't think they were doing it because they were minorities, right? So probably not. In addition, if enforced against independent service providers like individual plaintiffs and network companies such as Company Plaintiffs in a manner consistent with sponsor's stated intent to require the classification, AB5 would also violate the contracts clause of the United States Constitution and California Constitution. Now, the contract clause has been pretty much read out of existence in the United States Constitution. I don't even remember exactly what it says, but like basically there's like freedom to contract according to its text, but it's been like eviscerated. So it doesn't violate the contract clause. You would get Justice Thomas to say this violates the contracts clause of the United States Constitution, and that's it. There's no other justice on the entire Supreme Court who would pull that trigger. So if you want Justice Thomas's vote, you have that. But so it's ironic that this argument is appealing to, from a liberal state, this argument is appealing to the most conservative justice. But no one else will do this. No. No one else will do this. Justice Thomas will. No one else will. And I know that for a fact because he said that in prior decisions, by the way. That's not just speculation. I know for a fact he would because he said it before. AB5 would also violate the California Constitution. I'm guessing probably not. The on-demand economy is built on the structure of contracts in which consumers are connected with apps and independent service providers, not employees. Then they cite some federal case holding that a driver who used a platform is an independent contractor under California law. Yes, it was. And then guess what happened? California changed its law. So is this decision from the Northern District of California in 2018 relevant to the current situation? No, it's not. It was a holding under the old law. Guess what happened? California changed the law. So that decision has this much weight. It's zero. Compare California U.S. Department of Labor Wage and Hourly Division opinion later, recognizing app-based service providers are independent contractors under the Fair Labor Standards Act. Yeah, under federal law, they are. Under federal law, they are. But California can designate them any way they want. They can designate them as employees. They have control. So, is this opinion have any weight? No, not really. But thank you for mentioning it anyway, as I ignore it completely. Advice memorandum from the General Counsel Division of Labor Relations to some person concluding Uber X and Uber Black drivers are independent contractors under the National Labor Relations Act. Again, not relevant here. We're talking about state-specific law. State can change the law. They can say that they're contract employees. Company plaintiffs have entered into millions of contractors with independent service providers, including with individual plaintiffs, and millions of contractors with users of their app in reliance on the framework. Yeah. In fact, all those things are just like applying like default rules on default tests. I don't know if I could go so far as to say a state has absolute right to define employer and contractor any way they want. They probably do. All these things are just like applying standard rules that the IRS uses to like fill in the gaps because no state is like that strict. But if California said, we're just going to define everyone into these categories by our own whim, I'm not sure federal law has anything to say about it one way or the other. I think California can define this any way it wants. These are all just like default rules because most of the time it's unclear. But if California said, no, we're going to come along and we're going to define it with our stamp, I don't think this is a violation of federal law. I mean, that would be my default assumption unless someone can bring one to mind because like all these things are just trying to fill in gaps. If California says, well, there are no gaps now because we've just defined reality, I think they can do that. Yeah. 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 Wouldn't it be the state suing? The state would only be suing if federal law was conflicting with state law. So it would only be conflicting if they said these people are X and the federal government said, no, it's Y. But I don't think the federal government would say it's Y. I think they say here's a whole bunch of default rules, but I think California has pretty much freedom to do anything it wants, probably. If defendants are able to use the threat of enforcement on AB5 to force company plaintiffs to reclassify independent service providers as employees, even if the workers are correctly classified as independent contractors, they would completely upend this contractual landscape and at the very least substantially impair the existing contractual relationships, rendering many of them invalid and forcing plaintiff companies to enter into new contracts with dramatically different obligations. Yeah. But again, that's not really a problem of state law. Like contracts in general are governed by state law and state can change the law. And a contract that was valid can become invalid and one that was invalid can become valid. That's one of the things that you can do. And like, if that happens, then you modify the contracts to make them work under the new legal regime. So it's not like that big a deal. I mean, it's a little bit of a deal, but it's not that huge a deal, right? In the end, it's whatever. There's no significant and legitimate public purpose, only irrational animus. No. For the legislative attempt to incite enforcement of AB5 against network companies in a manner that would impair pre-existing contracts and harm network companies and independent service providers alike. I think that's part of the point. Yeah. Matthew says, couldn't they be independent contractors for IRS purposes but employee for California taxes? Yes, I suppose that like to the extent that the IRS is probably the one that has the big, and also like National Labor Authority for like unionization and stuff like that would have an interest in this. But there might be some caveats where like for federal labor law, they'd be one thing, but for state labor law, they'd be another thing. I mean, I guess it's possible, but like the federal labor things would probably not impair to a great degree. And it may be the case that it's unrestricted. I need to go deep into like federal labor law and deep into federal tax law to figure out if it's unrestricted or not. But my default assumption is that it's unrestricted. But you're right. There might be some like situations where they'd be one for one purposes and another for another purpose. That could be a thing. So that's possible. Plaintiffs' support of the goal of protecting workers and clarifying California rules, supporting worker classification, but singling out network companies and subjecting them to different rules is improper, ineffectual, and unconstitutional means of furthering their objectives. No. It irrationally harms network companies and app-based independent service providers by denying their constitutional rights to be treated the same as others who are similarly situated. No. These and other adverse consequences would also undermine the public interest in having access to app-based platforms that the network companies have created, with the attendant benefit of being able to hire independent service providers on demand with the click of a button. For these reasons, the court should enjoin. No, none of these things are valid. Then we get into who the parties are, which we don't care. We don't care about jurisdiction and venue. All right, let's read some facts. Now we've gotten past the poetry portion of the brief. Let's go to prose. If you have not already done so, and I'll remind you again, if you've not already done so, please give the channel a like. Please give this a thumbs up. I'd appreciate it from the 30 of you who are watching. Hopefully you're enjoying it. Hopefully you're enjoying me diving under the desk and all that stuff. I do it for you. Facts. Assembly Bill 5 sponsors attempt to codify and extend the reach of dynamic ABC test. Yes, that is what their goal is, yes. On December the 3rd, 2018, Lorenza Gonzalez introduced AB5. According to the bill, its purpose was to codify the decision in Dynamex and clarify the application. Okay. Dynamex adopted a three-factor test, or the ABC test, to determine whether a worker is an independent contractor or employee for the purposes of California industrial wage orders. The wage orders provide minimum wage, maximum hours, and working conditions. Fine. The wage order at issue in Dynamex imposes wage and hourly obligations for companies that employ workers, which the wage order defines as to engage, suffer, or permit to work. Construing that language, Dynamex concludes that workers are presumed to be employees for the purposes of wage order unless three conditions are met. So you're presumed to be workers and presumed to be employees unless three things are true. The employee is free from control and direction in connection with the performance of the service, both under his contract for the performance of the service and in fact. So direction and control, right? So those are classic tests for contractor status, direction, control. The services provided outside the usual course of the business of the employer, and the individual is customarily engaged in independently established trade, occupation, profession, or business of the same nature as that involved in the service performed. Fine. Although Dynamex applies ABC test solely for the purpose of California wage orders, which is fine, right? You can have different standards applied to different things. We do it in law all the time. AB5 codifies the ABC test for purposes of wage order and expands it to apply the entirety of the California Labor Code and the Unemployment Insurance Code. Yes, it does. And California can do that. California state legislature can say, wow, that was a really good decision. From that, they could do two things. They could say, wow, that decision really sucked. We're going to change our law to undo that order, right? Because if a California court is interpreting the California statutes, one of the things the California statutes can do is change. So the legislature can overrule the courts. And they can say, no, that decision sucks. We're going to change our law to undo that decision. You can do that. It happens every day. And by the same token, they can say, you know what, that decision was really great. And not only do we want that decision, we're going to adopt it and put it in a whole bunch of other contexts because we think it's a really good decision. So we're going to adopt it and put it all these other places. You only said it was a test for this limited purpose, but we really like this test. And so we're going to say it's a test for all the purposes now because we think it's brilliant. Legislatures can do that, man. What's the problem? Yeah, see, then they cite this court case explaining Dynamex did not purport to apply in every instance when a worker may be classified. Dynamex does not apply to non-wage claims. Sure, no problem. Dynamex does not apply outside those contexts. Okay, great. Can the California legislature change that? Yep, no problem. No problem. We think that's great. They say it doesn't apply. We say it does. We're masters of the law. Yeah, that's what you do. Specifically, Section 2 of AB5 adds a new provision to Article 1 of the Code that incorporates the test verbatim. Fine. It amends the definition of employee in the Labor Code by linking it to that new definition, and Section 4 amends a different section to incorporate the definition of employee. The Unemployment Insurance Code requires employees to pay unemployment insurance. Employees must also account for administrative costs associated with withholding unemployment insurance tax, paying them over to the state, keeping extensive records of transactions, and complying with recurring recording requirements. Yes, sure. When you are changing it, who is an employer and who is a contractor, that comes with a whole host of associated burdens. These are policy-based issues, things that you could bring to the legislature's attention as they're considering different things, which I presume you did, and I presume they ignored you, as they have the right to do. AB5 also transforms employment regulations into potential criminal liability. Okay. Any employer who fails to withhold or pay taxes, regardless of intent, could be guilty of a misdemeanor subject to fines of $1,000 for each occurrence and up to 1 year imprisonment. Yes, that normally happens with taxes. Although, without regard to intent is a little bit odd for a criminal statute. But okay. Additionally, employers who fail to comply with numerous unemployment insurance code provisions and regulations are potentially liable for dozens of penalties. Sure. Just a handful of examples include fines for failing to report the hiring of a new or rehired employee within a prescribed time. Yes, they need to know who is employees and not, so they can keep track of the unemployment taxes. Sure. Failing to report wages of each on a magnetic media or other electronic means. Okay. Filing false statements of withholdings to an employee. Yes, we don't like it when you file false statements. That's not good. Or failing to supply a required identifying number. Ooh, deep, right? And it's oh my God. Yeah. David McGuire says, imagine hypothetically there's somewhere where murder was legal. Then a law is passed making murder illegal. Then someone sues saying, well, it was legal before, so it isn't fair. Yeah, kind of, sort of. It's I've built my entire career on murders. The state legislature, yeah, we don't want to do murders anymore. We think murders are bad now. That's not fair. I've built my entire livelihood on murders. Well, find something else to do. Yeah, pretty much. Assembly Bill 5 says it stated it may be enforced by the California Attorney General or a city attorney of certain sizes or city prosecutors with the consent, blah, 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 whatever. The lawsuits may also seek injunctive relief to prevent misclassification. Okay, great. It's a state law. We can designate anyone we want. It's gotten a little darker. The light keeps changing. Hold on, I have to change the light. So make it a little brighter. Because I want you to see me. It's gotten a little darker. There we go. Change the white balance. It keeps changing on me. All right. At least one city attorney has already stated the intent to use this enforcement statute to do the job. Okay, fine. He's a law enforcement official that has been given authority, and he's going to use the authority to enforce the law. Yeah, film at 11, as I say. The exemption in the scope to the on-demand economy. AB5 spends only a few lines adopting the test, which, again, it's been established before. You don't need to spend a lot of time. You need to spend a lot of time establishing what it is if you're doing it for the first time, but you don't. A court has already done it for you. So it's just you just say, yoink, that's ours now. Why spend a lot of language on it? It's just go read that. You can do that. Why not? The vast majority of the statute is a morass of complicated provisions exempting dozens of occupations from that test. The legislature adds these carve-outs solely for interest groups and labor, as legislatures do. Under Section 2 of the statute, the exempted. I will get this camera to show me in the right light if it kills me. This is what happens when you turn off the auto white balancing, I guess. Under Section 2 of the statute, the exempted workers are governed by the alternative control of the work test from a different case. Sure. AB5 does not apply to Dynamex to these exempted workers. Right. They're exempted. How could it possibly apply to them? To exempt them is to say it doesn't apply. So you just wrote a truism. Thank you. That's brilliant work there. The Borrello test uses a multi-factor balancing test where no one factor is dispositive to determine whether a worker is an employer or an independent contractor. Yeah, so there are many different tests as we were discovering. I think the federal law is this 13-part test, but different people have adopted different tests, which are more or less the same in the aggregate, right? It's place of work, materials of work, hours, control, direction, independent skill. These are the kind of things you're normally working at, right? Ability to hold other jobs outside that employer, ability to work for other companies, that kind of thing. So that's basically the test in so many words. Courts applying this test have concluded app-based independent service providers are independent contractors, not employees. Yes, they have. Yes, they have. We're trying to change the law. Yes, courts applying the test of the multi-factor test have determined they're independent service providers. Right. The state legislature wants that to no longer be true. The state legislature wants to change the law. Why are we talking about these old court decisions? Why am I talking about court decisions that interpret the old law? Why do I care? I don't care. They're irrelevant to the issue. Yeah, here's a court that interpreted the old law. Under the old law, they reached this decision. The state legislature says, well, that sucks. We want a different law. So why do I care about these old court decisions? I don't care. No one cares. It doesn't matter anymore. We changed the law because the legislature gets to do that. Lord. Signaling that the exemptions were meant to allow independent contractor relationships to continue for the exempted businesses. Yes, that's exactly their purpose. Alexandria Assemblywoman Gonzalez say de Borzola was weighed heavily against trying to prove misclassification. Okay, fine, great. The statutory exemptions carve out most types of works traditionally considered to be independent contractors, with a glaring and independent exception, app-based service providers. Okay. And therefore what? They said, okay, here's a bunch of people we still want to be exempt, and you're not in the cool kids club. You're not in the exempt club. And I care because why? If I'm a court, I'm asking, why do I care as Judge Mueller? Why do I care as Judge Mueller about any of this? I don't care. I don't care about any of this at all. AB5 exemptions include blah, 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 blah. I don't care. There's no rhyme or reason to these exceptions. Do they need rhyme or reason? I mean, they need rational basis. Is there any reason to have them be in one status versus another? It's like, is there any reason for them to be one classification as another? Are the two things that are so close to each other, it would be irrational to split them? So that's the only thing I care about. Like, is there something on one list and not on the other list? And the two things are so close to each other that, like, I can't split the difference, and therefore it'll be irrational to have one on the one and one on the other, then maybe you'll get my attention. Like, if there are two things that, like, seem like the exact same thing, and you treat them differently, I'll be like, why? What's the rational basis for treating these two things that are exactly the same differently? Then I'd want a reason. Otherwise, if they're not, like, really close, then, like, treat them differently. Treat them the same. It's up to you. You're the legislature. You get to pass laws. Judge Mueller doesn't care because Judge Mueller interprets the law. Judge Mueller doesn't make laws. If he was Assemblyman Mueller, I might care a lot, but I'm not Assemblyman Mueller. I'm Judge Mueller. My job is to interpret the law, not write laws. The Assembly wrote the law. And they made choices. So unless, like, you can show me that one's in one category, one's in another category, and they're so close, it defies imagination. And then I start asking questions. I just don't care that much. Yeah. There's no rhyme or reason to these exemptions. Yes, there is. For example, it makes no sense to deprive exempt certain workers based on what type of license they have. Sure it does. Yes, it does. What are you talking about? Yes, it does. Drivers who work for transportation companies and use Uber Black for car, for instance, obtain government-issued business license for their transportation business. Yet AB5 treats them differently from other independent workers who must obtain licenses for their business. There's no such basis for disparate treatment. Sure there is. Sure there is. You have different kinds of companies, and they all need different kinds of licenses. They're not similar enough. The category you're trying to create is all companies that need licenses. And therefore, it's irrational to treat some companies that have licenses different from other companies that have licenses. Too big a category. All companies that need licenses is a pretty big group. It has a lot of disparate members. So it makes perfect logical sense to me to treat some differently than the others. So unless you can show me something that's a lot closer, I don't care. Many of the exemptions are wholly arbitrary. If they were truly arbitrary, it'd be unconstitutional. Please show me they're truly arbitrary, Uber. If they're truly arbitrary, it would be unconstitutional. The government needs rational basis, and something that is arbitrary is not rational. Arbitrary and capricious is not rational. So show me it's wholly arbitrary. This will be good. For example, a delivery truck driver is exempt while delivering milk, but not while delivering juice, fruit, baked goods, or meat products. Okay. A commercial fisherman is exempt when working on an American vessel, but not a foreign vessel. Yeah, foreign vessels treated by foreign rules. Sure, makes sense. A freelance editor or writer is exempt if you publish 35 submissions per year, but now she publishes 36. It is a arbitrary line, but that's not what we mean by arbitrary. That's not what we mean by arbitrary. Like anytime we're doing line drawing, anytime in law, you have to have a line. Whatever it is, like drinking age of 21. Why 21 as opposed to any other age? Is it arbitrary? On one sense, yes, but in another sense, we had to pick a number and it was as good as any other number. Is a perfectly reasonable answer. So like, yeah, it could have been 30. It could have been 30. It could have been 40. We picked 35 because seemed like a reason. It was part of our deliberations, and it was the number we came upon to as part of our deliberations. We thought 35 was the right number. Judge Miller says, fine, great, no problem. I don't care. It's a line. You picked a number. Sure, great. When asked about the 35 submission cutoff, Assemblywoman Gonzalez says, was a little arbitrary? Yeah. Yes, it is a little arbitrary, but not arbitrary within the meaning of the law. That's not what we mean by arbitrary and capricious. That's not what we're talking about. Yeah, it's a little arbitrary. It's a number we picked. We had to pick a number. So we had a clear rule. We want a clear rule. We had to pick a number. It's a number we picked. Is it a little arbitrary? Yeah. That's not what we're talking about when we talk about arbitrary. That's not what we talk about arbitrary. Arbitrary is like we're doing it with no rhyme or reason, we had to pick no rationale whatsoever. We're throwing darts at a board is arbitrary. We picked a number because we had to pick a number is not what we mean by arbitrary. Not what we had in mind. News articles report employees and workers in other industries, including truck drivers, therapists, and entertainers, say it's unclear how much AB5 will affect them, leading some to take precautionary measures, and others say they hope a court will clarify matters soon. Well, that's fair. I mean, the statute is new, and so it might be unclear and it might be weird in its application, and you might not know exactly what's going on. That's why you hire lawyers, and they help you figure it out, and you administer it best you can, and it's going to be fine. AB5 does not identify data, studies, reports, or other justification. It doesn't have to. It's a nice to have, but it's not a requirement to have. The legislature can just say, we think it's true. As long as they have some basis for thinking it's true, they have enough basis to think it's true. They don't need studies. It's nice to have, but not a requirement. The legislature included many exemptions as political favors, politically favored groups without a valid legislative purpose or rational basis. Okay, fine. To the detriment of platform companies. I do like the implicit argument here. The implicit argument is it's only unconstitutional because we didn't get an exemption, right? If Uber had gotten an exemption, they wouldn't be complaining about its unconstitutionality because other people wouldn't have gotten exemptions, right? So it would be just as unconstitutional if Uber got an exemption or not. But it's only constitutional from Uber because we didn't get an exemption. We weren't part of the Cool Kids Club. So it's like, yeah, I'm sorry you're not part of the Cool Kids Club, but sucks to be you. Yeah. Eva Coleslaw says they might have a claim if they did for Lyft and not for Uber. Yes, that would be like part and parcel of the same thing. That would be why one and not the other. That would be I want you to show your work for that. That I would say, yes, you need to show your work. What is your reason for treating those two companies this differently? But if it's like Uber and Grubhub, no. If it was Grubhub and some other food delivery app, yeah, maybe. But it's not close enough. In many months preceding the passage, the California Labor Federation circulated a one-page form that business groups could complete to request an exemption. Okay. These opt-out forms were the idea of the Assemblywoman, in turn worked to amend the bill to create a various exemption based on relative interest from labor groups and specific seeking exemption. So she's basically saying, I want you to petition me for redress. Here's a law I want to create. If you want an exemption, petition me so I can consider it, so I don't miss anything. Works for me. The process played out repeatedly and was responsible for irrational, arbitrary results in the final bill. No, they're like trying to create something. They're trying to create something, and she's like saying, okay, is there any reason like to treat one versus the other? Fishermen should be in this group, but only these kind of fishermen. These kind of people, but not these kind of people. Sure, why not? Works for me. Is it arbitrary? Was it done as political favors? Yeah, but that's politics. Courts don't do politics. Courts do law. It's not a protected class. The legislature is allowed to play political favorites. That's kind of what they do. They, by definition, play political favorites. Courts have nothing to say about this. Judge Mueller does not care. Assemblywoman touted the fact the bill reflected unions' bare political interest to rationally benefit friends and harms others, explaining at the time, I am a Teamster, I am the union. Okay, fine. That's fine. In weeks immediately before and after the California legislature passed AB5, the prime supporters of the statute and the interest groups that lobby for it repeatedly disparaged the on-demand economy and confirmed their purpose in promoting and voting for the statute was to target and harm network companies. For example, Assemblywoman Gonzalez stated a whole bunch of stuff, which I don't care about. Other lawmakers who supported it similarly attacked the on-demand companies by doing some other stuff. This representative said some other things. These well-funded lobbying efforts by old economy companies accomplished their mission to target network companies for rational treatment. As enacted, AB5 spends the majority of its text exempting dozens of occupations from reach after spending more than just a few words on its purported purpose of codifying Dynamex. Why do they keep coming back to this? Why do they keep coming back to the idea that there were only a few words in AB5 that were discussing the codification of Dynamex? Dynamex was already decided. The court already did it. Like, how many words do you need to say this test from this case called Dynamex we think is super and we want to apply in all the places? How many words do you need for that? They keep coming back to like, it was just a few words. How many words do you need? Not that many, man. I mean, it's already been done. So just be like, you know, that cool stuff over there, that's cool. Let's just, you know, read that everywhere. Read that all the places. How many words do you need? It's not like a lot. Jeez. Absent from the long list are network companies. That was no accident. So you're saying it was a deliberate political choice, which is like basically the opposite of what you want to say. It was an accident would be helpful. It was not an accident. In other words, it was a deliberate political choice. It's stuff legislatures get to do, for better or worse. Gonzalez vowed from the beginning that network companies would not make the list. It's not going to happen. Okay, great. And after AB5 passed, she tweeted in celebration that she fought Harv with no gig carve-outs. Okay, great. It was her idea. It was her bill. She didn't want them to be exempted. She thought that they should be regulated. Her goal was principally to target you. Yes, you have... Congratulations. Congratulations, Uber. You have successfully proved the obvious. You have successfully proved the obvious. Assemblywoman Gonzalez's goal was specifically to target gig businesses such as Uber. She had you specifically and directly in mind as a group of entities she wanted to regulate into employment status. And therefore, what? And therefore, as she was writing this bill, she knew Uber was in one category before she started. Her entire goal in life was to put Uber into a category. And as she was considering exemptions from other people, she considered them on its own merits and then said, "No, Uber, you don't get one. You're not a cool kid. You're not a cool kid. I want to regulate specifically you. You're the problem. I'm coming after you." Okay. I need like a graphic to show you the total number of fucks I give. You know, look at my field. It is fallow. You know, that kind of thing. It's like, that's how I feel right about now. In short, the principal legislative supporters and lobbyists behind AB5 have one goal in mind: target platform companies and attempt to force them to reclassify. Yeah. I've said many times on this channel, I'm a conservative justice. Okay, one of the things that makes me conservative is I look to the legislative language, right? I look to the language. I look to what the words mean, right? It was written today, so I don't need a lot of interpretation to try to figure out what the language means, because it means the same thing. So I just look at the text. I'm a conservative. I'm not a judicial activist. I apply the test that Congress, or in this case, the California legislature, passed. Do they have the right to pass it? Yeah, pretty much. Does it impact a protected class? No. Does it treat like one business that is essentially the same thing as different from another business? Not with respect to Uber. Maybe with respect to the milk/juice producers. If they want to bring a complaint as an as-applied challenge to them, we'll talk about it. But as either a facial or as-applied challenge to Uber, no. You know, if the juice people want to bring a complaint because they weren't exempt and the milk people were, I'll be happy to consider their argument, because those seem like two things that are similar. Now, I can imagine a reason why you'd exempt one, not the other. But, you know, I'll at least go so far as saying, hey, state of California, could you please give me a reason before I kick your ass out of court? These guys are just going to kick their ass out of court immediately. In the milk juice people, at least I'll ask first before I kick your ass out of court. So, hey, you got that going for you. I'm going to ask first. So you got that. That's a plus. So, yeah, I'm a conservative. I apply what you wrote. There are no constitutional issues that apply. The legislature is in control of the law. I apply the law. Not my issue. Would I vote for it if I were a legislature? Hell no, I wouldn't vote for it. But I'm not a legislature. I'm a judge. My job as a judge and my job as a legislature are two different things. I'm a conservative. Would I vote for this statute? No, absolutely not. As a conservative justice, would I uphold the statute? Every damn day. Every damn day. I wouldn't even blink about it. I wouldn't even think twice. Because that's my role as a judge, is to apply the law, not make up my own. You know, if I wanted to make up my own law, I'd run for legislature, not run for judge. So, you know, go talk to someone else. Lord have mercy. Substantial civil and criminal penalties may attach to state and private enforcement actions. Yeah. So the fellow says you don't believe in legislation from the bench? Not really. No, not really. Not really. You know, if you want a law passed, go talk to the legislature. That's what they do. You know, I'm here to do law, not politics. I just apply the law. Don't ask me to do politics. I apply the law. You want something else, go ask someone else. It's not for me to decide what the legislature should want. That's what the legislature does. They can argue about it. Once they figure it out, let me know and I'll go do what they want. As explained above, AB5 codifies the ABC test. A few examples of criminal penalties network companies could be threatened with is labor code violation for misdemeanors for not giving overtime, meal periods, alternative work weeks, makeup work days, and rest days. Misdemeanor for failing to pay minimum wage. Misdemeanor for violating certain provisions of wage withholdings. Misdemeanors for failing to comply with itemized pay stub requirements. Felonies for imprisonment for failing to make certain required payments to health or welfare funds, vacation plans, or similar benefit funds. In other words, if they're an employee, you have to treat them like an employee, and you have to do the paperwork that's associated with an employee. And we, the state legislature, want you to do that. That is our goal and mission in life. Yes, you have correctly deduced and understand what we want you to do. We want you to do all these things, and if you don't, we're going to whack you over the head because you're not complying with our law. So, you know, yeah. Yeah. AB5 also extends the ABC test to the uninsurance code for various violations. The Private Attorney General's Act. Now, that's a pretty cool law in California specifically. One of these days, I probably should cover it in more detail, but I need to understand it more to cover it more in detail. But there is a law that, at least in some circumstances, gives an individual to act as the Attorney General and sue people for violations of state law. Now, I know it has come up, the context where I know it's come up most often is for Americans with Disability Act requirements, handicap requirements. So one things that individuals will do is go around from place to place, even though they're not disabled, and basically troll businesses to make sure that, they're in full compliance with all the things. And because they get money out of it for doing it. And, whether or not that's a good line of business or not, it's a legal line of business because they're finding whether or not they're in violation of law. California likes it because they find the violations. They don't have to put their own enforcement mechanisms into place. So it's rather than putting our own inspectors, rather than putting our own police forces on this, rather than us do it, we're going to create a bounty program. We're going to create a bounty program. So if you, the private individual, find a violation, we're going to give you a cut of whatever fines we get. So, yeah. But so there might be a bounty program here too. They get to do that. That's fine. The Private Attorney General Act of California authorizes employees to sue to recover civil penalties for violations, including misclassification. I bet it does. I bet it does allow them to do that. That would be part of the goal from California's goal. Yes, we have authorized our Attorney General. We've authorized these various state prosecutors to do it, but we can't possibly look at every business in the state of California. So we're going to create a bounty. Hey, individual who works for this business, if your employer is in violation, why not prosecute them? You get to be the state of California, and we'll give you a cut of the proceeds. Excellent. Employees may sue on behalf of themselves or other employers of the state of California. Yeah, that's exactly right. In addition to seeking civil penalties, they may assess that allows private plaintiffs to seek a civil penalty of $100 for each aggravated patient and $200 for each aggravated person. Yes, I'm sure it does. I don't care. There are millions of app-based independent service providers in California. Company plaintiffs separately contract with thousands of independent service providers, like independent plaintiffs, many of whom use the app-based platforms on multiple network apps. Yes, I'm sure they do. If network companies are forced to change, blah, 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 I don't care. Yeah. If AB5 were enforced against company plaintiffs in manner consistent with the state-sponsored intent, it would cause substantial economic harm. Okay. Look at my field. It is fallow. It is empty. Look at all the fucks I give. I give none. I don't care. I'm not the legislature. I don't care. I don't care about any of these things. These sound suspiciously like policy arguments. They sound suspiciously like policy arguments. No. No. It's like, why am I here? Why is Judge Mueller here? Go talk to the state legislature. They're the one that created laws. Did you lose your way? Did you lose your way? Do you not know where the legislature is? I could give you directions if that's the problem. Maybe you thought the court building was the legislature. It's not. What you need to do is you need to walk out the door and go out the main door and turn right and go about a half mile. It's on your left. I know, a simple mistake. No problem. That's about how I feel about this. Company plaintiffs and many other similar situated companies build their business on creating apps, websites. These companies operate on-demand platforms for those willing. It's because of freedom. Many workers would stop demand, blah, blah, blah. I don't care. And then we're going to talk more about Lydia. We already talked about her. She needs flexibility. We talked about Mr. Olson. We talked about Perez and his life. Postmates is a technological company that operates an online marketplace and mobile platform connecting local merchants, consumers, and independent, blah, blah, blah. To begin making deliveries, a courier must accept a fleet agreement, which provides the parties intend this to create an independent contractor and not that of employer-employee. Okay, great. You, as a matter of private contract, want to establish your relationship. That's super wonderful. I'm thrilled for you. However, your contract also has to operate and be compliant with state law. Here's a secret you may not have known. You can't contract for illegal things. And if illegal things are in your contract, they're void. They're void. You can't, in fact, contract for illegal things. And the state gets to determine what is legal and illegal, and they get to change their mind. They could say, this sucks, we don't want to do this anymore. So it's like, we are super, super thrilled with you that you want this relationship. That's really super interesting. But we, the state legislature, look at our field. Look at how fallow it is. We don't care. We don't care. Your contract will bow to our will. And then I, as a judge, say, okay, well, look at their field. They don't care. I don't care either. Each courier is free to use as much as they want. If AB5 were enforced, Postmates would be forced to do business. Uber is a technology company, ride app to begin using drivers. To begin using, it states in bold text, the relationship between these parties is that of an independent contracting parties. It's not an employment agreement, nor does it create an employer relationship. The state legislature, look at our field. We don't care. Look at how empty our field is. And Judge Mueller says, look at our field. We don't care. Look how empty it is. Like, I don't know what you want. There's no typical driver who uses the app. Drivers have individual choices to determine their circumstance. Each independent driver is free to use the app as much or little as they want. Drivers use their own vehicles and tools, maintain own maintenance, oversee their own appearance, and determine their own driving routes. Yes, these would be typical indicators of independent contractor status. I agree. As a matter of standard run-of-the-mill law, if Judge Mueller was being asked to decide, are these people contractors or are these people employees? Judge Mueller would be inclined to say, well, standard run-of-the-mill law, these people are independent contractors. They use their own tools, they set their own hours, they determine whether or not to accept a particular engagement. Even in Uber, like it's set, you can decline particular engagements. They can go offline at any time they want. They can come online anytime they want. They're not subject to direction. They're not subject to control. You know, they can work for other companies. All right, as a matter of standard run-of-the-mill law, applying the multi-factor test, I don't have a particular problem saying they're independent contractors. I'm hard-pressed to think of a single factor that makes them employees. You know, I can't think of one. There probably is one. It's a 13-factor test. There probably is one or two that applies that makes them employees. But on balance, are they independent contractors? Sure, as a matter of standard run-of-the-mill law. But here's the thing. California just changed the law. California just changed it. They said, no, we don't want run-of-the-mill law. We want this ABC test. And as a judge, I'm like, well, who am I to object? They don't want the 13-factor test. They don't want run-of-the-mill law. They want the ABC test. I'm going to go apply that now. Are you independent contractors or not? Go figure that out. So, like, you know. Does anything illegal in the contract to validate the entire contract or just that part? It depends, I suppose, how central it is to the contract. So, yeah, it's basically trying to, it's basically making a particular provision inoperative or the whole thing inoperative. So it depends on the nature of the contract, right? So it's it's the same like with a statute, for that matter. If a court is striking down a portion of a statute, the question is, are you striking down just the portion or the entire statute? And the answer there is basically, if you're striking down a portion, then the judge kind of has to fix the statute on the fly, which is annoying because it's not really what judges do. But then by the same token, they want the legislature's intent. The legislature gets to control the law. So the legislature passed this huge law. And so if they have one provision in it that's unconstitutional, the judge says, well, this one provision is unconstitutional. Can I fix this law so that, the whole thing's going to work? And if so, then great. And the judge fixes it. And the legislature can, of course, fix it more. But yeah, it's the same thing in contracts. It's is it central to it or not? Is it ancillary or not? If it's one thing that's ancillary, it's we'll work around it. The court, you go into court and say, we can't perform this contract. The court will say, okay, you can't perform on this section, but I'm going to change your language for you and change this. And, see what's going on. So, yeah. Yeah. So it depends how central it is. Same with the law. That's basically the answer. But a contract for an illegal service is void. So all you people out there who have contracted for murder for hire, your contract is void. Murders are illegal. Sorry. Many drivers who use the Uber Drive app marketplace provide transportation services to earn supplemental income when convenient for them while working as an employer. Other drivers accept referrals, blah, blah, blah. I don't care. As with network companies, it would harm us. I don't care. Matthew said there was something in the Uber contract at one point that didn't allow them to drive for another. Fair point. I don't think that's the law. I don't think that's the contract anymore. If I were interpreting the law, if I were interpreting the employer-employer status, that factor would definitely go against them, right? If you say you can't work for other people, that makes you more an employee. So, that would be a thing. Can I keep the money? No, strictly speaking, you have to give the money back. Also, everyone's going to prison for the rest of their lives because you've entered into a conspiracy to commit murder. So no, you don't get to keep the money. The money, well, technically the money's going to get seized by the government because it's part of your fine. But yeah, you don't get to keep the money because it was for illegal services. So the whole thing is void. The contract doesn't exist. And by the way, everyone goes to jail forever. So, don't do that. Many other companies use it. 300,000 people will lose their jobs. Reducing the number of drivers in reduced area will cause these harms. Contracts make clear they do not have certain obligation. Oh my God, this is good. These contracts make clear that companies do not have certain obligations to the workers as employees under the labor code. Well, that's super wonderful, interesting. Let's look at the labor code to figure out if that's actually true or not. Well, what do you know? The California legislature just amended the labor code. They disagree with you. They disagree with you that you don't have obligations. You do have obligations. I know your contract says you don't, but you do. Because I'm looking at the statute. It says it right here. Statute beats contract. You know? Statute beats contract. Yeah. If AB5 were enforced, it would cause us problems. These massive costs would cause companies, independent service providers. Yeah. California may once again regulate businesses out of existence. California is not the most business-friendly state, as you may have noticed. They have a nasty tendency of regulating people out of business who then flee to other states. So, again, California is going to impose, and they're going to kill another business. Genius, California, for being stupid and for creating situations where companies have problems operating and can't operate businesses, and it kills your entire economy. California, last time I looked, you're having a massive budget problem. Here's an idea. Maybe if you stopped regulating businesses to death, they would pay taxes, and then your state would not be in so bad. And maybe if you spent less, that would be good too. But you, the state legislature, get to be idiots. Me as Judge Mueller, am not going to stop you from being idiots. I may write, in my opinion, as I'm upholding your law, you're a bunch of complete morons. I might throw that in there as a footnote. You, the legislature, are complete idiots, and you don't deserve to breathe. I might throw that in as a footnote, but I'm still going to uphold your law, as I'm telling you you're stupid. So, yeah. These adverse consequences would be especially substantial for multi-app. I don't care. Okay, so there's a whole lot of I don't care. That was genius work from Uber. Let's read their claims of relief. Declaratory relief, violation of the Equal Protection Clause. No, Equal Protection Clause doesn't apply because Uber nor these people are protected classes. All we need is rational basis, and we can treat different people differently as long as we have a rational reason for doing so. Yeah. AB5 violates the Equal Protection Clause because it draws classifications without rational basis. It's like, get out of my courtroom. That's how I feel about this. Get out of my courtroom. Just get the hell out of my courtroom with this stuff. I can't even be bothered. Get out. Likewise, the statute draws irrational distinctions between independent providers, blah, blah, blah. Laws unconstitutional singling out certain class of citizens for disfavored legal status are rare. No sophisticated economic analysis is required to see the pretextual nature. It's not pretextual, it's textual. It's what they're trying to do. There's no rational distinction between network companies and main network companies. Yes, there is. Any rational basis will do. It's not hard. This type of singling out in connection with rationale so weak it undercuts the principle of non-contradiction. Strict scrutiny applies. Whoa, strict scrutiny applies. Well, we're getting ballsy. Strict scrutiny. Ho. Okay, tell me why strict scrutiny applies. This will be good. Strict scrutiny review applies because AB5 is designed to burden, and if enforced against independent service providers and network companies in a manner inconsistent with stated work, it would button the fundamental rights of companies and workers to pursue their chosen profession and determine where and when and how they earn a living. No, not even close. Not even close. In addition, there's no rational basis for targeting companies for disfavored treatment. For example, ostensibly exempts business-to-business services, freelance writers, grants writers, graphics designers, insurance agents, direct sellers, manicurists, hairdressers, and real estate agents. The independence, autonomy, and characteristics of these types are substantially similar to app-based. Not substantially similar enough. Not substantially similar enough. Can I separate what Uber does from what real estate agents, hairdressers, manicurists, direct sellers, insurance agents, graphics designers, grant writers, freelance writers, and business-to-business services does? Can I make a distinction from Uber, from all these businesses? I think I can. Doesn't require a whole lot of effort. Doesn't require a whole lot of effort to say that they're distinguishable. How is Uber like any of these things? because they're all, in some very broad, general, obscure sense, independent, autonomous, and therefore they're substantially similar. Get out of here. Get out of here. If Cal's story and legislator goal in establishing AB5 were truly to protect workers and prevent employees from skirting their earnings, the statute would not contain dozens of exemptions. No. None of these things. The state of California can make decisions. It has chosen to exempt certain businesses and not others, for policy-based reasons, for political reasons, for political favoritism. For all I care as a judge, I do not care. I don't care. It's not my business. I don't care. Whereas here, the breadth of statute is so discontented and with certain lurkers, blah. Not only is animus towards the on-demand economy the only possible explanation. Okay. Congratulations, Uber. I am 100% sold. The state legislature has animus for this. I don't care. That's probably why they passed a law against it. Normally, when you have animus, you don't pass laws in favor of it. And if you think it's great, you don't pass laws against it. Normally, passing laws against something somewhat implies you have animus against that thing. Yes. So sure, you've convinced me. They have animus against you. What? Why am I here? Why are any of us here? This is stupid. The public record's filled with statements who legislatures attacking the platforms on unscrupulous business tactics. Okay, great. The sort of malicious, irrational, and planned arbitrary action defeats under rational relation test. No, it doesn't. It's malicious, it's not irrational, and it's not arbitrary. No. The manner in which the exemptions further confirms the statute violates equal protection. Many exemptions result from backdoor deals, not a valid legislative purpose. There's a footnote. Is the footnote helpful? How do you qualify for an exemption? Answer. Persistence and presence. Better hire a lobbyist. Of course, it helps to be a political supporter. Yeah, no shit. How do you qualify for an exemption? Pressure? It would help to have a lobbyist? Yeah, and it would help to be a supporter. These would be things that would be helpful to a legislature as they're considering whether to exempt you or not. Politician responds to political incentives. Ooh. For example, among truckers, only those who tow disabled vehicles or haul building constructors obtain exemptions. Sure. Platform companies also sought to express exemption, but were denied exemptions. Yes. Okay. Legislatures may not draw lines for the purpose of arbitrarily excluding individuals. That's true. They can't arbitrarily exclude particular individuals. That's correct. Including by doing so as a concession to one constituent but not another. They're not targeting individuals. They're targeting businesses. No. Just no. If they were specifically targeting, like, because you have two plaintiffs in this, if they were specifically targeting these particular plaintiffs, then sure, those particular individuals would have an equal protection argument. But they're not. They're targeting businesses. They just happen to work for those businesses. They don't care. They literally don't care about those individuals. They literally don't care at all. They could work for the company or not. They literally don't care. They don't care. They would regulate you all the same. It makes no difference. They're not targeting individuals. They're targeting businesses. It's something they get to do. Although the legislation proposed claim the statute will prevent exploitation if enforced consistent with contracting with independent contractors, and will instead void. AB5 will instead void their valuable contracts with network companies and cripple their fundamental right to pursue lawful occupation. Yes, you are correct. It will void their valuable contracts, or it will have to be modified substantially to comply. Yes, it will void their contracts because their contracts are now for an illegal thing. Wow, you have stated basic principles of contract law. You cannot contract for an illegal thing. You are correct. It will void their valuable contracts. Yes, it will. Amazing. Deep. Wow. While simultaneously carving out a laundry list of exemptions of dozens of classes of contractors who are equally exploited. Well, maybe, maybe not. Maybe they are equally exploited, maybe not. And some of those exemptions are time limited, I'd like to point out. The hairdresser's thing is time limited. The fisherman, I think, is time limited too. And maybe they'll come back for those people someday too. Whatever. By a sponsor's logic, it makes more likely the exempted business will be exploited given the statutes exempt those workers than they otherwise would be. That doesn't make sense. They'll be just as exploited as they would be before. They're not going to be more exploited than they would be before. They're in the same category they would before. Nothing is going to make them more exploited. How would it make them more exploited than they were before? That doesn't make sense. So disconnected with reasons, it's inapplicable for anything but animus towards the class, relaxed rational relationship, and violates equal protection. Plaintiffs have no adequate remedy at law. Well, as to that, my friend, you are correct. You have no adequate remedy at law because this is not legal. This is some bullshit. That's what this is. Declaratory relief, violation of Constitution for equal protection. No. Violation of Constitution, inalienable rights clause. All people are by nature free, independent, and have inalienable rights. Among these are enjoying and defending life and liberty, acquiring and possessing, protecting property, and pursuing and obtaining happiness and privacy. No, not even close. If it did, it would violate pretty much any business regulation, which it doesn't. So no, thank you for playing. To the extent it is enforced consistent with sponsors' intent, deprives network companies of rights of forbidding them from any chosen work. No. Impose massive obligations. Yes, but I don't care. The interference with these rights is unreasonable and arbitrary. No, it's not narrowly tailored. It doesn't have to be narrowly tailored because it's not strict scrutiny or intermediate scrutiny. It is a rational basis. It is not. Oh my God, they're talking about strict scrutiny now. They're talking about strict scrutiny now. This is strict scrutiny language, guys. They're talking about strict scrutiny again. AB5 is not narrowly tailored to any compelling governmental interest, nor is it the least restrictive means. That's strict scrutiny language. That's strict scrutiny language. That would be the test if strict scrutiny were applied. If it were discriminating on the basis of race, for example, then we would be talking about this. But it's not. We're not in strict scrutiny. It doesn't have to be narrowly tailored to a compelling interest and be the least restrictive means. It has to be reasonably related to any government interest and any means. All of them. Anything will be fine. We're not in a strict scrutiny test. The fact that you think this is strict scrutiny is blowing my mind a little bit, I have to say. Wow. It's not even rationally related to any government interest. Yes, it does. It has no substantial relation to public health, safety, and morals, or general welfare. Yes, it does. It's not congruous with any legitimate office. Yes, it does. Unrelated to interests of workers because it outlaws working relationships, blah, blah, blah. Oh my God. AB5 is promoted by animus towards the on-demand economy. These purposes show that any proffered rational basis is illusory. Wow. No. Woof. No. Violation of U.S. Constitution's due process. California businesses have a constitutional protected interest in operating free from unreasonable government interference. Yes. Unfortunately for you, this is reasonable government interference. Businesses are therefore protected from baseless or invidiously discriminatory standards that have a right to be free from excessive and unreasonable government conduct intentionally directed towards them to force them out of business. Probably true, but we are nowhere anywhere close to that. The public record is replete with evidence showing California's legislators supported it in an effort to isolate and harm platform companies, if not put them out of business. Probably. Sure, why not? Legislative circuitous path to legitimate ends while direct path shows it lacks rational basis. If California wanted to provide independent service providers access to certain benefits, it could have provided a more direct and less restrictive means. For example, platform companies advocate for legislation that allow for the creation of independently administered portable benefit funds into which all rideshare companies would pay. The fund would pay for a series of benefits, including paid sick time, work time, and disability coverage. Independent service providers would own these benefits and keep them. Okay, well, that's a reasonable thing to do. It's a reasonable offer to the legislature. It's a reasonable thing that you can offer them. It's like, I understand that you're trying to accomplish certain goals, and we can accomplish these certain goals by these other means. And this legislature said, nah, we're not interested in that. They could have said yes, but they said no. Either option was fine. They said, nah, that's an interesting offer, but no, we don't want to do that. We want to do this other thing instead. Does it have to be like more narrowly tailored? Nope, not really. This sounds fine. The malicious and arbitrary purpose of the statute combined with the backroom dealing creates a wholly arbitrary standard in violation of due process. No. I feel like I want to look at counsel and be like, really? 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 Yeah. For substantially the same reason, violates the due process clause of the California Constitution. No. Violation of the constitutional Ninth Amendment. This will be good. This will be good. Plaintiffs incorporate all other paragraphs of the complaint. The language and history of the Ninth Amendment, which basically says in so many words that there are other rights we didn't mention, the history and language of the Ninth Amendment reveal the framers of the Constitution believe that there are additional fundamental rights protected by government interference, which exists alongside fundamental rights specifically mentioned in the first 8 amendments. The right to work of one's own terms as an independent service provider rather than employee is one of these fundamental rights. Wow. That's interesting, guys. It is a Ninth Amendment violation if you don't allow someone to work as an independent service provider rather than as an employee. Wow, that's a lot. That's wow. That's I somewhat admire the cojones of that, man. The right to work on one's own terms as an independent service provider rather than as an employee is one of those fundamental rights protected by the Ninth Amendment. Wow. Oh, man. Oh, my God. For substantially the same reason, it violates Article 1, Section 24 of the California Constitution, which apparently is colloquially known as the Baby Ninth Amendment, which I'm going to assume also doesn't apply for the same reason the Big Boy Ninth Amendment doesn't apply. Wow, that was good. Violation of California Constitution's due process clause. For substantially the same reasons, it would deprive due process of the California Constitution. No. Violation of the U.S. Oh, this is a good one. Declaratory relief. Violation of the U.S. Contract Clause. Article 1, Section 10 of the Constitution. No state shall pass any law impairing the obligations of contracts. Yes. It says that. It has been rendered mostly I won't go so far as to say nullity, but pretty close. You'd get Justice Thomas's, at least, interest in this argument if this went to the U.S. Supreme Court, which, by the way, there's no chance in hell this is going to the U.S. Supreme Court at all, anywhere. But if you could get to the U.S. Supreme Court, Justice Thomas would show some interest in this argument because, he'd actually argue for this as a straight text. He'd argue for it on literal meaning, but no. But thank you for playing. Company plaintiffs are parties to valid contracts with the independent service providers, including the individual plaintiffs. These contracts establish that workers are independent contractors. If AB5 were enforced, it would violate our contracts, blah, blah, blah. No. But thank you for playing. Yeah. Would severely undermine our contractual bargain, substantially interfere with reasonable expectations. They have no reason to anticipate that AB5 would effectuate dramatic departure from prior treatment. Yes, you did. You knew this issue was percolating for years and years and years. You absolutely knew this was coming someday. Screw you. You had every reason to anticipate this. Screw you. The classification of independent service providers, including individual plaintiffs, as independent contractors, have obvious value. Purported reclassification as employees prevents from safeguarding, is not drawn an appropriate, reasonable way, no legitimate public purpose. Impairment of contracts was not drawn with moderation and reason. Was not. This is good. This is good, Matthew. This is good language for your future legal practices. AB5 was not drawn with moderation and reason. So you can look forward to using that in a future legal complaint someday. You should use that language. That's really like just top-notch legal language. Moderation and reason. Wow. Just that's good stuff. Oh my God. That alone convinced me. I changed my mind. Uber has the greatest case ever. Did not exercise police powers. Did not reasonably advance the purpose of protecting workers. Narrow focus was not enacted to provide any social interest. Extensive legislative purpose is suspect. Forced reclassification unreasonably and substantially interfere. Yeah. Violates the contracts clause of the U.S. Constitution. Ooh, and is actionable under 1983. Under 1983 for deprivation of rights by a state. As a judge, I just want to know, do I have to give this any time of day? Can I just summarily dismiss this? I mean, do I really? Can I just summarily dismiss this? Do I have to have any argument at all? Just be like, sua sponte, dismiss with prejudice because this is stupid and lame and there's no hope. I want to dismiss this with prejudice, sua sponte on first action. I want to dismiss this before even the response period is due. I just want to dismiss this right out the gate. Dismissed with prejudice. No, absolutely none of these things. Absolutely none of these things. You have zero cause of action at all. Injunctive relief. No. These injuries are balanced. The harm favors public features. The public interest favors injunctive relief because many members of the public on contractor staffs would burn in ridges. Well, you know who might also be considering the public interest? The state legislature who passed this law. They're the ones who work for the public interest too. They passed a law. They think it's in the public interest. As a judge, I'm going to defer to them. Yeah. A Hedinger says I have to read it. I did read it. We've been reading it together for the last hour and 52. I read it. I'm ready to rule. I read it. I'm ready to rule, man. I am ready to rule. I don't need any more. Plaintiffs asked this court for appropriate relief. How about laughing in your face as appropriate relief? How about that as appropriate relief? Laughing in your face and telling you that you're dumb. How about that as appropriate relief? How about I make you wear a sign outside the courthouse that says, I'm dumb and my complaint is dumb. How about that for appropriate relief? I could order that. That'd be good. Enter judgment declaring AB5 is invalid and unenforceable because the enforcement is intended by statute sponsors would violate equal protection. No. Because it would violate inalienable rights. No. Enter judgment is invalid because enforcement violate contracts clause. No. Not even remotely close. First of all, I'm conservative, but not that conservative. And even if I were that conservative, no. Because the case law does not represent my view. Would represent the view. The case law does not support that. If Justice Thomas wants to do it, Justice Thomas can do it because he's on the Supreme Court. Justice Mueller is not doing this. First of all, he's not the conservative. And second of all, just no. It's not in line with the case law. Permanently enter injunction, grant plaintiffs reasonable attorney's fees under 1988, no. Grant plaintiffs such additional relief as the court deems just and proper. Signed, Thean Evangelis. Argument for the plaintiff. And we demand a jury trial. How about no? How about no? Does no work for you? That would be good. Well, that was well worth our time, I think. I think we enjoyed that together. Did we not enjoy that together? I think we enjoyed that together because we got to read a whole bunch of stupid, and it was just stupid on levels that, we got to fully appreciate and contemplate, and, it was really just good stuff. So yeah. So that is good stuff. So let's see if there were any chats that I missed along the way. Incidentally, if you'd like to give me a super chat, I won't say no. Just remind you that I'm here, and it'll be nice. Let's see what else we got. Yeah. Everyone pretty much agrees with me that it's stupid. If all government buildings were in the same neoclassical style, it would be easier to distinguish between branches. That's a good point. Yeah, that's fun. Yeah, maybe you're just in the wrong place. Maybe could I give you directions? Yeah, you seem to be confusing me for the legislature. I'm not. I'm a judge. It says right here on the little nameplate, judge. I don't know if you can read, but I'm happy to give you directions. What you want to do is leave and go out and yeah. No, yeah. In EU, consumer contracts need to be as short as possible and easy to understand. So adding legal sections makes the whole contract void. I don't know if that's true under EU law or not. I have a hard time believing it's true. I mean, short as possible is goal, but I would imagine there might be an illegal provision, and I doubt that would kill the whole contract. But I don't know EU law well enough to disagree with you affirmatively. Yeah, this would be like a textile factory suing for the outlaw of child labor. It would be a lot like that evil coleslaw. Yes, it would be a lot like that. Suing for the outlaw of child labor. You know, we depend on all those children laborers. You know, we need them. It's going to harm our business. Yeah. We're targeting you because we're targeting you because you employ children. They're targeting us because we employ children. That's not right. Oh, Lord. Yeah, idiot videos leave and infect other states. Yeah, that's a problem. Yeah. Overall, California is killing it right now. Well, the California economy might be killing it, but the state budget's not killing it. So, yeah. So, I don't know what the state budget's doing wrong, but the economy is going good. Yeah. Did they raise the dead, the guy who argued Lochner? Yeah, this would be some Lochner-esque shit. You know, if we want to go back, there's ways to do this, but like the current court is not going to do this. There's no federal judge who will uphold this, and there's no judge that's crazy. No. This reads like a 2L exam answer. I'll disagree with that. It reads like a very professional wrote this. I mean, it's a whole bunch of stupid, but it reads like a professional wrote this. It reads like someone who is really reaching to reach a particular conclusion, which I guess, is the job of a lawyer. They're trying to represent their client as best they can, and they certainly went for every bit of what they're being paid. So I'll disagree that this reads like a 2L answer. A 2L could not write this well. I couldn't write this well. This reads like a real professional who really, really thought about it and really did a good job and is earning their $500 an hour. Now they're going to get their ass handed to them in court, but they're trying. Incidentally, I don't think Uber's really trying to win. I think Uber's just trying to buy time. I think is what they're trying to do. I think they're literally trying to buy time, because you figure, like, how much is this lawsuit going to cost them? I mean, they're probably in six-figure. They're probably spent a couple tens of $1,000s on this brief, and they're probably contemplating hundreds of thousands, maybe $1 million to fight this case. But if they can get a court to like actually consider it, if they can fight this through appeals, it's probably worth it to them for just the time. They're probably it's probably more economical for them to spend this money knowing they're going to lose just to buy time. So they know they're going to get struck down, but they figure they'll buy a couple months of time while the court is wrestling around with it. So I think that's what they're trying to do, is just trying to buy time. And then they're hoping to get on the ballot next year for a ballot measure and get the whole thing mooted by, the people and during a ballot measure. So I think that's what they're trying to do, is buy time until next November. So that's what I think they're trying to do with this lawsuit, is buy time. So I don't know if that will be successful or not. Judge Mueller would kick it out the door and tell them to go appeal and, do it quickly, because, I don't want any part of this, but, I think that's what they're trying to do, is buy time. I'm not interested in helping them buy time by misusing the legal process, though. If they had an actual case, I'd be happy to consider it. But, if what you're trying to do is buy time, courts don't do that either. Courts don't allow you to buy time. We consider legal cases, and you don't have one, go away. The alcohol industry got their ban removed. Yeah. Can you come up with anything that's at least not a hard nope? Can I come up with any argument that's not a hard nope? Let me think, Matthew. Can I come up with any argument that's better than what Uber's lawyers came up with? No, I can't come up with anything better than Uber's lawyers thought of. Not unless I can really show like that Uber is so close to another business that's not being regulated. And I've read the statute before, and I pretty much know they're not. So I know that argument doesn't work. The some sort of takings argument, I bet it's a regulatory taking, but throw that in there for what the hell? Why not just throw in a Fifth Amendment argument while we're at it? That won't work either, but why not? Let's throw that in there. Maybe seizure, throw in a Fourth Amendment argument. That'd be good. Um, Excess fines clause. Should use Eighth Amendment. Um, Freedom of association, First Amendment. Um, no, I got nothing. I have absolutely no argument that wouldn't pass the left test. I have no argument that I would have to like grit my teeth at. I can't think of anything that would work. Um, Matthew, if you think there's an argument, the IRS preempted the field. No, I don't think so. Preemption is a nice idea, Matthew, but the ability for states, even if you argued, no, because the case law on preemption is clear. To have preemption, it has to be explicit. Congress has to do it explicitly. You can't implicit your way into preemption. Congress has to make it explicit that they're preempting, and they didn't do that. So no, preemption, no, it doesn't work. They didn't preempt the field in terms of regulating this. No, no, but nice. Um, Ninth, yeah, I'd like to see it. You get used for anything ever? Not really. Interstate commerce, yeah. If you want, I think the federal government, I think the federal government could probably regulate this. If I think Congress probably could override California if they want to. So like, but that's still like okay. So what you want to do is you want to go out the courthouse, turn right, and go about 2,200 miles, and go to D.C. and see if they'll pass a law. Because yeah, this would be interstate commerce. If Congress wanted to regulate it, they probably can. I think they probably can regulate this. They can make California do something different. So sure, if you can get Congress to pass a law, go nuts. Yeah. Um, yeah. Uber writes good comedy. Probably shouldn't file it. You just need to give us your best legal argument. I don't know if I have anything better with this. Yeah. What are you? I'm an idiot sandwich. I remember that from Gordon Ramsay. Very cute. Um, Someone wanted to know which Chevron case was the famous case. What is the name of the famous Chevron case? Yeah, Chevron versus NRDC, 1984. I'll post a link from Wikipedia so you can see that. Yeah, Chevron versus NRDC. That's the famous Chevron case that I hate and want to die. 1984. Yeah, hate it. Hate it very much. The old standard we had before that was fine. Um, yeah. All right, so that's the end of the stream, guys. I that covers it for 2 hours. I really hope you had a fun time. If you've not already done so and you like this stream, for the 28 of you who are watching, please give the stream a little like. I would appreciate it. And if you have story ideas you'd like me to cover, um, you can tag me either in Discord. I'm on Lawful Masses' Discord as Blackleaf, or you can go to my Facebook page and message me on Facebook. It's Uncivil Law on Facebook. Those are two good ways to get in touch with me. If you want me to cover a story, I will put it on my story list and I will get around to it as time allows. And I'm always happy to have you and have you here with me. Happy New Year, everyone. I hope it's the best and happiest New Year. I hope 2020 treats you well. I hope the decade to come is everything you hope it will be. And, feel free to celebrate a little tonight, that we get to welcome in a new year, guys. Until later, my friends, I hope you're well. Cheers and goodbye.